So, Mr. Parker, when is your meeting?
Starts at 1 o'clock and it's over at the Housing Authority.
Okay.
So that's only a 15-minute. Doesn't take 15 minutes to get there.
And how long does it typically take for you?
Well, it takes longer, but I got someone else from my office attending part of it. That way I can come right back. So if we left, say 1:45, I should be back here by 2 o'clock. So an hour and 15 minutes.
And Your Honor, if you want to keep plowing ahead, we can do motions that other attorneys are assigned to.
Right.
So if you want to just take an hour break and we can find some of those.
This is what I think we'll do. It's 1:45 now. And when would you get back, Mr. Parker? What time?
I can be back by 2, Your Honor.
Okay, just want to make sure. we're on that. And then we have tomorrow. How are we doing as far as the motions?
Good. We're making good progress, Your Honor.
Okay. It's going a lot
As soon as
quicker.
they say that, you go backwards.
I don't think so. I mean, in all candor, the court's heard the real water MILs before.
I'm sorry. This is what we'll do. We'll break at 12:30. That way, Mr. Parker, you don't have to rush.
Thank you.
And then we'll anticipate starting at approximately 2 o'clock.
Thank you. Thank you, Your Honor.
Okay. Okay, next up will be,
The next one we have document 513, MIL number 28. That one has not been opposed and actually been joined by Albertsons. So I believe it just could be granted.
okay, and we're on, I guess, motion and limiting number 28. On that docket numbers again.
513.
Okay, and we'll go ahead and grant that one.
The next one I have on our list is document 514. Plaintiff motion limiting number 29.
13, is that going to do an agreement?
Unopposed.
Okay, thank you.
Your Honor, I got this one, MIL number 29. And it's to preclude real water from soliciting expert opinions from Brent or Blaine Jones about whether or not outbreaks were limited to the Henderson plant or extend to other locations. Given how this trial went, the Gallagher trial, I'm sorry, the Hun-Watson trial and the Wren trial, I don't know how much of this real water is going to try to get in, or it's really
Hey,
opposed.
Teddy? I can actually probably short circuit this a little bit if I can jump in.
No, go right ahead.
So Your Honor, just very briefly, real water in the past, we have not attempted to elicit this testimony from Brent and Blaine Jones. I don't anticipate doing that during this trial either. My only point and the only reason we oppose this is that we believe that if lay witnesses are going to be limited to lay testimony, it should apply equally to both parties and to all parties' witnesses. And that's all I have to say on this one, Your Honor. So anything else Teddy wants to talk about, I'm game to go through though.
And wasn't this more of an issue with the distributors anyway?
Yeah, Your Honor,
Yes.
you're right. In terms of the other locations, they were trying to differentiate the issue between jugs and retail bottles.
Right.
And so I don't recall real water making an issue of this during the 3 trials. And so that's why I think it can be granted, and I think we will judge, we will act accordingly from the plaintiff side. We're not seeking to get epidemiology opinions from lay witnesses, Your Honor.
Right. Anything else, sir? I just want to make sure I don't overlook you.
No, Your Honor. Thank you.
Okay, I'll go ahead and grant it.
Thank you, Your Honor.
We have an agreement on the next one, 515.
It's off,
With motion remains.
number 32.
Number 32, and what is that one, man, for the record?
Docket number 515.
And that's plaintiff's motion eliminating number 32 to preclude reference to plaintiff Carla Morenos and Hunter Brown's criminal history. We'll grant that.
Non-op, Your Honor. Number 7.
Next up is 518 plaintiff's motion eliminating number 7.
Your Honor, this is the one that is related to motion in eliminate number 1 on the alcohol. So the alcohol causation opinions of Dr. Tanner and Dr. Robbins would be out. With regards to Dr. Tanner, I don't think there's anything left of him, so I think he's all the way out.
I think that's, well, I want to make a record, but I agree that if to be consistent with the prior MIL, his opinions would be out if the court sticks with that. Yes, I agree.
Okay, now with Dr. Robbins, it's slightly different situation, Your Honor. He is not all the way out, the way I read it, because this case has a little bit of a different twist than Gallagher had. In the Gallagher case, we didn't have any biopsy slides of anybody. In this case, there's actually, can I have Daisy Weeze up? This is a biopsy slide that was taken, Your Honor. They stick a needle into the liver, they pull out biopsy, and then they do stains on it. This is a trichrome stain. And the reason they do the stain is they're trying to detect permanent liver injury. So if you see this,
I think we did have some in the Gallagher case.
just a little bit.
Yeah.
Yeah, remember we had the article up?
Yes.
So this stain is from Daisy Weed, who's one of the 15 plaintiffs in the case. She's actually one of the 4 people that's discussed in the article, Burke article. So that came in just a little bit, but it's been I think developed a little more in the last 2 or 3 cases. So in any event, in this particular case, Daisy Weed's one of the plaintiffs. So we're gonna have Dr. Gatnow come in and give his opinion with regards to this slide. Basically, without getting into a lot of detail, if you look at kind of it's making a little circle there. That's in our view, that's either a precursor to cirrhosis. And cirrhosis, there's 5 portal tracts in each one of those circles. So what happens is the fluid comes through the portal tract. The fluid would be what contains the hydrazine, the rocket fuel. So the hydrazine damages the port in the area around the port, and then they bridge from one port to another. That's what forms the circle. So when you see a circle here, you see a circle, that is the either cirrhosis or the precursor to cirrhosis. So there's going to be a lot of pathology testimony in this case. And with regards to Dr. Robbins, we have not sought to preclude his he's gonna talk about what he thinks of this slide and some of the other plaintiffs. We haven't asked that portion of his opinion be excluded. So we think that this shows bridging fibrosis and or nodular cirrhosis, and it potentially can lead to liver transplant. I think his opinion is going to be that either it could progress or regress. We don't know. We're not trying to preclude that. His discussion of the biopsy slide interpretation, but we do think that he shouldn't be allowed to give any causation, like the alcohol or anything else. And really, the alcohol was the big one. So I think it should be granted. Dr. Tanner all the way out. Dr. Robbins out as to causation opinions, but not out with regards to these pathology points I've discussed. Or there may be some other pathology points that we
Your Honor, Joel Odou on behalf of Real Water, I'll just address the pathology opinion. So I think the question that Real Water would have is where we're going to draw the line. In other words, Dr. Robin is pathologist. There's no doubt about his qualifications. He looked at the liver that was removed from Mr. Henry, and the question we would have is plaintiffs seeking to exclude all of his opinions as to Mr. Henry's removed liver. And it seems like they are. And so I'm going to address that argument. Certainly his opinions as to the liver that was taken from Mr. Henry meet the assistance requirements under Hallmark. They meet the requirements under the Williams and Muscato case. There's no doubt that the real water experts considered hydrazine as a cause of the injuries. In fact, we'll get to Dr. Alsina in the next motion. Dr. Alsina concedes that some of the plaintiffs were injured by or likely injured by real water and hydrazine. So the real question is where we're drawing the line for Dr. Robin. We think his opinions as a pathologist are helpful to the jury, do meet the Williams test, do meet the Hallmark test, and should be admissible. Really, I have nothing further to add.
Yeah, Judge, so Tenner's out. We agree to that.
I believe just so the record is clear, we're not stipulating that Tenner is out. We agree that the court's prior ruling would exclude Dr. Tenner.
And with regards to Dr. Robin and the liver, so they took Mr. Henry's liver out. We've got a picture of it. They chopped it in half, Your Honor, which is standard protocol because they want to see what it looks like. So, I think some of his observations on the liver is fair game, but if he tries to backdoor in the alcohol, I don't think that is fair game, and that's what I'd be concerned about. I don't see how his examination of the liver, if it's not as to causation, gets us anywhere. Because if it doesn't go to causation, that liver's not in Mr. Henry anymore. It doesn't have anything to do with his prognosis in the future. It's the new liver that would. So if there's no causation to it, I don't see how it's relevant. And so I think any testimony that he has with regards to Mr. Henry's liver, I think would be inappropriate because they're not arguing that there should not have been a liver transplant. There's no argument made of that. The argument is to what the causation was, and that's already been excluded with regards to the alcohol.
Not to quibble, Your Honor. I think the opinion that plaintiffs frame this issue as a claim that the real water experts claim, which they don't, that Mr. Henry's alcoholism occurred over a 2-year period and caused him to have the liver transplant. That's not what they said. They claim that his liver transplant was caused by alcohol abuse. There was an argument, and the record is quite clear, that it can take 10 years or more, but it can also take less, and that the most common cause in people aged 25 and over is cirrhosis of liver caused by alcohol. Yes, Mr. Henry was 22 at the time, but I think the record speaks for itself. The court has made its ruling. But I don't want the record to be jumbled as to Dr. Robin's opinions that are being challenged in this motion. Certainly, if the court is going to exclude all of his opinions about the liver explant that was taken out of Mr. Henry, that's fine. But I don't want it to be conflated that we've either conceded that or that the prior ruling included that, because I don't think it did. I just want the record to be clear. If he's being excluded for opinions regarding Mr. Henry's liver removed for some reason, then I think the record should be clear on that. His opinions are on causation. He says, look, this is an alcoholic cirrhosis liver that was taken out of Mr. Henry. I understand the court's prior ruling. I'm not trying to re-argue that. And if then by extension, that means he can't testify as to his findings as a doctor that this liver was damaged by alcoholic cirrhosis, that's fine. I just want to make sure the court's going that far.
Okay.
Yeah, Judge, I think you got to go that far because that was motion to number 1. You can't get 98% of the causation, let another, the other 2% back in by saying he looked at the liver. So I think Robin should be excluded from saying anything about Henry's liver. Again, I'm not asking that he be excluded with regards to Daisy Wee's path slides or the other path slides and his opinions on those.
Yeah, I just want to make sure I'm clear on where we're at as far as Robbins is concerned, as far as his opinions, because it appears to me there's probably 2 issues here. Number 1, what is the status of the liver cirrhosis? Number 2 would be what's the cause? Is that where we're at?
Yes, Your Honor. That's right. A cirrhotic liver could be caused by toxic liver injuries such as hydrazine.
Right.
It could be caused by alcoholism, excuse me. He considered hydrazine as a cause. He looked at the liver, it's his medical opinion, to a reasonable degree of medical probability that it is alcoholic cirrhosis. Plaintiffs argue, well, it had to happen within 2 years because we have no records of Mr. Henry prior to a certain time frame. That may be, but the medical opinion is reasonably based. It's to a reasonable degree of medical probability. It's
Oh, how many, here,
There's no science.
yeah, well, I was getting ready to get to that because,
It's not a science, but yeah, I get you.
no, it's the healing arts. I understand that. But, you know, am I missing something in this regard?
Yes, Your Honor.
When it comes to cirrhosis, ultimately, there's no argument or no disagreement, I should say, that this liver, unfortunately, the cause of whatever damage there was cirrhosis, right?
The liver is cirrhotic. Both
Cirrhotic.
pathologists agree on that. He made a specific finding in his report as to the findings of the liver and why it is cirrhotic from alcoholism and not a toxin like hydrazine. He made that specific finding. If the court believes that finding does not meet the hallmark standard and is going to exclude it, then he can't offer it. But he did make a finding based on his observations, based on reasonably accepted methods in the pathology community.
And when you say that, what do you mean?
I'll pull up the exact quote that he had. It'll take me 1 second. It's in our brief.
Yeah, Judge, he also said he couldn't rule out hydrazine as a potential cause, but we're just talking about the first motion again.
No, I understand.
Yeah.
I mean, ultimately, this is what it comes down to. He can have an opinion, but there has to be a factual basis for the opinion as it
And there
relates
is,
to.
and if the court believes that factual basis is insufficient, we understand. I just want to find it and just have a very clear record. It'll just take me 1 second.
That's why we want to drill down, just to make sure.
Your Honor, it appears, it's quoted on page 7 of our brief.
Is that a line 10?
Yes, Your Honor. And I could read it, but the court sees it there, and those are his findings. And he points out where his findings agree with the literature and agree with Dr. Robin. I'm sorry, Dr. Datnow.
And so I guess the critical issue is this, the quote, documented history of heavy alcohol use. It does it, and he doesn't make a reference to the time period.
No, Your Honor. And see, that's I think where the parties disagree. The plaintiffs argue in its argument that it takes, a certain period of time to develop alcoholic cirrhosis. The medical literature says, yes, generally it takes a certain period of time, 10 years or whatever. Dr. Robin, independent of that, says I can look just like Dr. Datnow, just like any pathologist can look at a liver, especially one that's been removed, and render an opinion as to what caused the liver to become cirrhotic.
Yeah, Judge, we're right back to the.
No, I got it. I'm just making sure we got a clear record. What else do you want to add, Mr. Kemp?
I just want to say there's no science. I mean, he can't say, forget the fact there's no science. I see something. That's really what this boils down to.
That's what pathologists do all the time. It's part of their practice.
I mean, ultimately, and I respect the doctor, Dr. Robbins, and potentially what his opinions are, but don't his opinions have to be based upon the current state of the science? And what I mean by that is 10+ years of alcohol consumption.
Your Honor, it's based on, as a doctor, he considered hydrazine. He even says hydrazine exposure from real water cannot be entirely ruled out as a contributing factor. So there's Williams right there. He's considering plaintiff's theory of the case.
Well, actually, we understand Williams isn't in a vacuum. You got to read it with, you got to read it with Hallmark. It has to meet the assistance requirement. And that's my concern, is whether this, I mean, I'm a bottom line it. Does this opinion meet the assistance requirement under Hallmark?
It does, Your Honor, and reasonable pathologists can disagree.
Your Honor, you cannot possibly meet that because under Hallmark, you have to have science.
You do.
You can't just say, okay, there's no science. I can't give you one single article, but I see something. That's what this boils down to.
And I think it's important to really point that out, because I don't have Hallmark right in front of me, but they discussed the issue regarding peer reviewed, tested, and can be tested. And I mean, I think doctors are really smart, but sometimes what doctors do, they think that they have the ultimate opinion on specific issues, and whatever that opinion might be, it still has to be tested. It has to be generally accepted in the medical community.
It is tested, Your Honor. Reviewing a pathology slide is tested in the medical community. Different pathologists will arrive at different opinions. Plaintiff's pathologist looked at the slide and says it's from a toxic liver injury, non-alcoholic cirrhosis. Our pathologist disagrees, and he should be able, goes to the weight of the testimony, he should be able to offer his opinion in rebuttal.
There's no science, Your Honor.
No, I get,
Science in the plaintiffs.
no, but I mean, at the end, no. What's the standard for cirrhosis, liver injury caused by alcohol consumption?
10
10
to
plus
15
years.
years. 10 to 15 years, Your Honor.
Yeah, and so if I accept this opinion, we'll extrapolate time. He became a heavy drinker at 14, at a minimum, right?
Not at a minimum,
Why not?
because alcoholic cirrhosis develops at different stages in different people. It's not a straight line. It's not, everybody is not the same.
Well, it'd be nice if we had an article that said that, Your Honor. They haven't cited one single article that says that.
That is what the
Okay.
articles say.
Instead, they have Dr. Lynn, who says 10 to 15 years. That's their hepatologist. Dr. Poordad, their other hepatologist, says 10 to 15 years. And Dr. Robbins said that the literature says 10 to 15 years. That's what they have.
The literature
Okay.
says generally.
Okay. Anyway, we have a great record. That's why I enjoyed that. And so in looking at his report, and ultimately, whatever opinion a physician has, or any expert, there has to be an appropriate foundation for that opinion, number one. Number two, it has to be generally accepted in whatever specialty there might be. It has to be tested and subject to testing. And the bottom line, I look at it from this perspective. Hypothetically, if we had a foundation that the alcohol consumption was 10+ years, I got it, but we don't have that. And that's really what it comes down to. So going back to the question, let me look at it again. As far as number 7, this is motion in limine number 7, right?
Yes, Your Honor.
I'm going to grant it based upon speculation and also lack of foundation for the opinion. That's more so, I think, the real important issue. And specifically, it goes to the assistance requirement under Hallmark.
Thank you, Your Honor. You show docket 519, plaintiff's motion limit number 10 next.
Yeah, the root candle.
No, it's the root canal. And then we'll go. It's docket 519.
So this could take a while, Your Honor.
Let me find it.
I don't know if we want to skip this one or if we
Yeah,
can,
we can skip it.
because this one may take a while.
Yeah,
Um,
we have no problem skipping it and coming back.
What is number 10?
What's the maximum?
We did it in the real water ones.
What about the chainsaw?
Which are the motions for somebody?
33. We were not 33.
Pardon? Number
I
10.
think 33 comes later, yeah, I'm not seeing
Okay.
it. I show real water, MIL 2 would be next, if we could. So that would be docket 523.
All right. I'm on that one, so I'm fine to do that one. I don't think it'll take as
I
long.
don't think it's gonna take long at all. The court's already heard this one.
Yeah. Right ahead.
I think. Did we argue this?
Yeah.
Maybe we didn't.
No, you argued it after the fact. 'Cause
Gallagher, because you argued.
My
it.
opening was done in Gallagher, and then you said, okay, I'm not gonna let that happen again. Then you argued it in Hudson.
Ah, okay, well,
We let it go.
judge ruled against me either way. So.
Yeah. Yeah, that is true.
Different judge.
Right.
That's true.
All right, sir.
All right, Your Honor, this is Affinity Lifestyles Real Water's motion limited to preclude the use. Or what we would argue is misuse of the MMWR peaks. So a couple things, just housekeeping wise. I think in the MMR article, there's some additional things that need to be redacted. We have, I think, cured that over the last couple of trials. This came up in the Hunwardson case and later. Basically, the MMWR article talks about the 2020 peak being related to real water, but it doesn't talk about peaks prior to, I think it's 2018. Plaintiffs have argued, look at all these peaks, they're all related to real water. We don't think that's a proper inference. And we would seek to preclude that argument. Oh, and I believe Judge Kishner and Judge Hardy denied this motion unless I'm mistaken.
That is correct.
That's it.
That's it. All right.
I didn't have to deal with this one, did I?
You did not. You actually heard the argument during your trial. It was the first time I used it, first trial we had, so it was the first opportunity to use it. And I think that Real Water didn't like the argument and then raised it in front of Judge Kishner and Judge Hardy. And like Mr. Odou said, both judges denied this motion. Your Honor, we believe that the case law, first, the Wilson Circus case talks about common exposure. And then the MMWR report, Your Honor, which is a publication by a governmental agency, self-authenticating, typically comes in, it's an exception to the hearsay rule. Talks about, and as a matter of fact, can you put the chart on? There we go. Now we're talking. So, Your Honor, you remember this chart from our opening.
I do.
And you also probably remember that we had plaintiffs in 2018, which is Mr. Belsky. Mr. Haley was in 2019, and then we had 2020 plaintiffs as well. And so it was weird when we were getting ready for trial that we noticed that these peaks seem to correlate to our client, some of our clients in this case, in the Gallagher case, and it's repeated itself in terms of the other cases we have, including this fourth trial, Your Honor. And so the case law allows for attorneys to argue inferences based upon admitted evidence, Your Honor. And I don't believe that Real Water is contesting the admissibility of this document. So we certainly have the right to point out to a jury that these peaks correlate to claims that we have in this case. And so I think that's the long and short of it, Your Honor. The case law that we're using to support our position is the McFarland case, which is a Nevada case, 1993. The Klein versus State case, which is a 1989 case, going all the way back to the State versus Teeter case, which is a 1948 case, Your Honor. And so, and generally the case law says that counsel enjoys a wide latitude in arguing facts and drawing inferences from evidence. And Your Honor, that's all we're doing here. Again, in terms of why the MMWR report is an exception to the hearsay rule, we would refer the court to NRS 52.085 and NRS 51.155, Your Honor.
Can we leave that up? Be quicker. Thanks. Okay. Your Honor, we're not contesting that the report is admissible. We're contesting that, for example, if you look at the 2016 peaks, the plaintiffs are going to argue a particular plaintiff falls within one of those peaks. And as you'll see, Your Honor, this is trends in monthly inpatient diagnosis of toxic liver disease or acute hepatitis failure, unspecified, Clark County. So the authors of this report don't know what these different peaks and valleys are, don't know specific patients. We would anticipate that plaintiffs are going to say, well, here's where Trevor Abley goes, here's where Gray Maynard goes. And Your Honor, that's just speculation. We don't know their cases were reported to the public health authorities, that they were captured here. We just don't know. We're just going to speculate. And they're also going to argue that all of this is caused by real water. And we don't know that either. All we know is the cases at the end of the chart that were traced back, if you will, by the public health authority.
Your Honor, I actually think that what Mr. Odou just said supports this motion, because it, I think, highlights the independence of the governmental agency that created this report. It's no accident that after they checked this database and they came up with these peaks that had nothing to do with the plaintiff or the defendant at the time, they weren't doing this to benefit one side or the other. This is simply data that provided this chart. And then through our investigation of this case, we find that several of our, 63 plaintiffs, we don't represent all 100 of the plaintiffs in this case, in addition to the claims, the customer complaints, fit quite nicely in the peaks on this chart. Mr. Kemp was just telling me how Mr. Watkins, who was in the hospital in towards the end of June, beginning of end of May, beginning of June of 2018, he fits right in the peak. And then Mr. Haley and Mr. Belsky fit right in the peaks. Now, this report is related to non-viral hepatitis, and their consumption of real water during this time, including the hospitalizations, line up with these peaks. And nothing is better than the November 2020, when all 5 of the children were also sent, or came down with acute non-viral hepatitis and sent to the Utah Children's Primary Hospital. So there's a relationship. And what I will tell you, based upon my review of the real water opposition, they have no cases that prevent the plaintiffs from making these, I would consider, very reasonable inferences based upon this report and the timing of the hospitalizations that these plaintiffs received, Your Honor. And there's just no case law that they pointed the court to defeat this motion.
Thank you.
I don't have anything further to add.
Nothing further. And I just pause for a second and oh, yes. And I just wanted to remind everyone we have Nevada Pattern Jury Instruction 2.0. And the way I kind of look at it is this, and number one, it's coming in. Secondly, there's an issue regarding whether or not the plaintiff can make arguments. And remember, there's 2 types of evidence, both direct and circumstantial. And it appears to me that what the plaintiff would be offering would be circumstantial evidence, lining it up and say, look, we don't have direct evidence, but circumstantially, this is what we have. And this is important to point out because in pattern jury instruction 2.00, it provides as following. Circumstantial evidence is indirect evidence, that is, proof of the chain of facts from which you could find that another fact exists, even though it's not been proven directly. You are entitled to consider both kinds of evidence. The law permits you to give equal weight to both circumstantial and direct evidence. And it's argument. That's ultimately what it is, right? And I'm gonna deny the motion as far as the exclusion, because I see it as a circumstantial evidentiary issue.
Thank you.
Because they just line up.
Thank you.
Okay. Now, I don't know if other judges ruled that way, but
They
that's,
did,
they did that.
they did, no.
Okay.
Mr. Odou, real water MIL number 3, is that next?
That is next, yeah.
This one, Your Honor, not to steal your thunder or your glory.
Okay.
This one, Your Honor, I believe has been addressed previously with the prior claims. I think we agree we're not gonna mention settlements. We're not gonna dispute that. We're not gonna bring or try to bring in evidence of settlements or judgments. Or even lawsuits, but the claims, I think that's all been addressed already.
No, I appreciate that. Your Honor, this one, we refined as well during the Hunwortson case. And in particular, there are two issues that we see may arise in this case. One of those issues, and when Ms. Parker says claims, I think those are the issues, the claims of other plaintiffs in other cases. And so as an example, we heard argument a few moments ago. This is just as an example, there's nothing nefarious about it, of the 5 babies that fall within the MMWR. We would argue that the claims of those 5 babies have been adjudicated in the Wren case, and to argue injuries to plaintiffs who have already recovered from real water in terms of a verdict would be improper. And so, for example, we may have arguments about the Gallagher baby. We may have argument about Mr. Haley or Mr. Belsky or any of the plaintiffs in any of the other cases. And so our motion is a little bit more broad. And in one of the issues that hasn't come up yet is we may hear argument from plaintiff's expert, Dr. Datnow, about his review. Well, maybe not. Dr. Datnow has an opinion that Severin Morales's pathology slides taken in that were discussed and admitted in the Wren case over our objection because it was a new opinion, show that he developed cirrhosis within 2 years of drinking real water. Now that alcohol has been excluded from Mr. Henry's claim in his cirrhotic liver, perhaps we're not going to try and introduce Severin Morales, but we would argue that Severin Morales has had his day in court, has had a jury verdict, and to introduce evidence of Severin Morales's pathology slides in this case is inappropriate because the only issue in this case, and again, it goes for the purpose of which it's being offered. The purpose of which being offered is to inflame the jury and for punitive damages, and that's improper because Severin Morales is already recovered in that other case. And so, while I appreciate that the claim has, or I'm sorry, that some of the motion has been resolved, some of it is very much alive in terms of once we open the door and allow plaintiffs who have recovered in other cases to have their claims introduced to this jury, it's prejudicial and it has no probative value. And the probative value of any Dr. Datnow testimony regarding Severin Morales has now been eliminated by the court's exclusion of Dr. Robbins' opinions as to Mr. Henry's cirrhotic liver, because now he will not be giving those opinions, so there's no need to rebut it with Severin Morales.
Different motion too.
Thank you, sir.
Your Honor, I think that there's some confusion between Mr. Odou and myself, or between Real Water and the plaintiffs on this point. The Severin Morales slides showed a child who actually, based upon our pathology review of his slides and the, do you have a slide? Based upon the pathologist's review of the slide of his liver, showed cirrhotic nodules. And Mr. Kemp showed the court in looking at Daisy Wee's trichrome slides, the beginnings of cirrhotic nodules. He showed bridging fibrosis. Cirrhotic nodules is a more progressed damage indicator to the liver. And so we don't have to mention that Severin Morales has already been compensated through the Wynn trial, but we do get the opportunity to show what harmful effects hydrazine has on the liver. And we use that slide, not unlike the Loma Linda slides, where again, another governmental agency determined that hydrazine, even small doses of hydrazine, because some of the consumption reports in the Loma Linda report was only 2 weeks worth of consumption of real water, still resulted in fibrosis and bridging fibrosis. So this child, who's never had any alcohol, was shown on his pathology slide to have necrotic cirrhotic nodules on it. And so we want to show the progression. We want to show what these plaintiffs may have in store with them based upon what hydrazine can do to a normal liver. Those who have never had alcohol. And so Daisy Wee's slide is one of 4 patients in the Loma Linda case. Now, Mr. Kemp calls it the Burke article, because Burke is the #1 named author on that report. I call it the Loma Linda because it was done in Loma Linda. All 4 of the patients were seen there. But it shows the bridging fibrosis, Your Honor. It shows what can happen based only on the consumption of hydrazine, which was the contaminant in real water, without any consumption of alcohol. And so we do believe, and our experts reviewed these documents and reviewed the slides and reviewed the Loma Linda report. And we'll be able to testify that this is what happens when you consume hydrazine. And this is the type of damage that is permanent. So each of the other trials, and certainly in the last trial, we were able to use the Loma Linda report to show the damage done to a normal liver based upon consumption of real water. And in the Severin, using the Severin slide, Your Honor, the doctor, our hepatologist, was able to testify that these are the types of slides indicating the type of damage that can be caused by hydrazine for each of the plaintiffs. And so, unfortunately, or fortunately, I guess, biopsies is an invasive procedure. So, and it's not medically appropriate to do for every person. But we have the benefit of these slides that we can apply to each of these plaintiffs. So we can inform the jury, this is the type of damage that these plaintiffs have been exposed to. And so that's the reason behind it. But going back to the 4 corners of this motion, we don't have to mention that Mr. Severin went through a trial. We don't have to mention that the 5 children went through a trial to be able to discuss them, because in fact, the 5 children are part of the FDA report, Your Honor, which has been admitted. I don't think there's any opposition to that. So we believe that the reports, the government reports on the 5 children have already been admitted. That's not an argument here. We should be able to discuss what that report says. The Loma Linda report has been admitted. We should be able to discuss the slides of the biopsies for those 4 patients. And Severin Morales, who's also been biopsied, and without, of course, talking about the Wren case, we should be able to put that in there because our experts have reviewed that and relied on those reports in determining the progression of liver damage based upon the consumption of hydrazine, Your Honor. So that's where I believe this motion, what this motion addresses, and why we will agree that we won't mention the lawsuits, we won't mention the judgments, but we should be able to discuss this factual information that supports what our experts are saying, which they relied upon and have been deposed on, Your Honor. And in fact, our pathologists, as well as our hepatologists, they've been not only deposed, but they've been taken on cross in front of the, in trial, John. All three trials with Dr. Hudson. So, Your Honor, I think for that reason, this motion should be denied as to these documents, but we will agree in terms of judgments and lawsuits.
Two quick points, Your Honor, Joe will do for real water. First, Dr. Datnow changed his opinion. So we had a 16.1 violation in the Wren case. Judge Hardy allowed the testimony, the new testimony. It was never in the disclosed opinion, that we never had an opportunity to rebut. It was allowed into evidence in the Wren case that'll probably be part of post-trial motions and consideration. Why we would want to introduce that argument and the potential error in this case does not make any sense to us. Second of all, plaintiffs are trying to use that testimony as the Sever Morales, that new testimony that came out at trial for Sever Morales. In this case, it will confuse the issues. It will inflame the jury. Plaintiffs already are going to use the fact that infants have been injured by real water to inflame the jury, despite the fact that none of them are in this case. And we've had a runaway verdict in the Wren case. We don't want to see a runaway verdict in this case, Your Honor. The danger of prejudice is very real and has happened already. And inviting prejudice in this case by allowing the arguments of Sever Morales to somehow bolster opinions as to Daisy Way's liver just doesn't make any sense. There's no need for it. Daisy Way has her own independent case. Sever Morales has recovered and had a verdict in his favor in the other case. And to now introduce that evidence in this case is doubly prejudicial and should be excluded.
Here's my thoughts in listening to this issue. And it can't be overlooked that this isn't an isolated event or exposure. What we have here is, I guess, a public health outbreak in consideration, and that's why the governmental agencies and entities got involved in the investigation as far as this health crisis, I guess is the best way to say it. And they want to find out specifically what the cause would be. And I think that's a little bit different if you had maybe two separate events that resulted in harm, and one would be like two motor vehicle accidents or something like that. But here we have many people that were exposed to hydrazine. And so when I look at it from that perspective, it appears to me that the plaintiff is offering these additional slides, number one, to individuals, no, I should say of individuals that consumed real water. Secondly, and this is, I think, the real issue, what happens to the human body and specifically the liver when hydrazine is ingested? Isn't that really what we're talking about?
Absolutely.
That's what the issue is. And there appears to me to be no factual issues as it pertains to the consumption of real water, right?
Sure. But there was no, in fact, Your Honor, Real Water conceded liability as to those children, including Mr. Morales, Sever Morales. So there is no factual dispute there.
And that's really, I think, the distinction, because I can see in other types of cases, of course, that wouldn't come in. But based upon the unique nature and character of this case, we're talking about a mass exposure. I think it does come in. And I understand why Judge Hardy ruled the way he did in light of all the exposures. And I think that's the difference.
Agreed.
You know, it's a products liability case.
Your Honor, I think that also solves motion eliminating number 7, which addressed the pathology report specifically, right?
I think we're at a lunch break. I'll look at that.
Yeah, then let's go to lunch.
All right.
So next up is that 525. That would be,
I think we were going to do a me too on this number 7.
I think we gotta make a record on number 7. I agree with you. It's gonna be a quick one, but are we going to go back? We missed the one.
that 518.
Yeah, the Rucam one. Yeah, that way we won't forget.
You wanna go to MI plaintiffs, MIL number 10?
I'm still looking for it.
Yeah, it's 10. Is it
Yes, that's right.
519 or 518?
Doc 519.
19.
Your Honor, do you have that one teed up?
Whatever, I can go anywhere.
So plaintiff's motion limiting number 10, Your Honor, I indicated earlier would probably take a little while.
Yes, I remember him.
Yeah, that was a little
Thank you.
So, Your Honor, Dr. Alcina has been retained by Real Water as a hepatologist to provide opinions regarding the causality between Real Water and their acute liver injuries or gastrointestinal symptomology. And he uses, Your Honor, a software program, an algorithm to determine causality. And so,
How would you do that?
good question. Great question, as a matter of fact. And that's exactly what our motion, where our motion goes, Your Honor. Our motion is to,
And did he author the computer program?
no, he did not author the program. The program's been around for a while, and there's been updates to it. And in fact, the most recent update, I believe, is called, instead of RUCAM, it's called RECAM, RECAM. Which is supposed to be an improvement, but I don't believe he used RECAM. And so we start out in our motion, Your Honor, highlighting for the court that this RUCAM algorithm, we can't cross-examine it. We can't put Mr. Algorithm, he or she, on the stand and figure out or examine the interworkings of it. Now, one thing that we did highlight also is the fact that Dr. Alcina did not provide all of his scoring in this report. Real Water's opposition points out that we could have requested it and that it was produced in the last case. It didn't become an issue in the last case because ultimately Real Water conceded causation. But in this case, they're still arguing about causation, Your Honor. And since it's a part of Dr. Alcina's report, I believe under Rule 16.1, he should have produced the scoring. But it was not. Even if he had produced it, Your Honor, we still couldn't cross-examine an algorithm. And so, Your Honor,
You'd probably have to cross-examine the coder.
That's right. That's right.
I mean, really?
It does not pass the Williams test. It doesn't pass the Hallmark test. There's no test that it does that it would pass. And unlike, for example, and I was working on this yesterday, actually Saturday, and if this was let's see, an MRI or an X-ray, Your Honor, that's something that doctors utilize all the time. It's a diagnostic test. It's objective. Mr. or Dr. Alcina admits that the RUCAM algorithm has some subjective components to it. It's very difficult, if not impossible, to distinguish or differentiate between drugs with some temporal sequence to some known hepatic toxic potential from Real Water in this case, because in his analysis, he never actually inputs hydrazine, a known liver toxin. He simply says Real Water and compares that to all alkaline water. And that's what he does. He uses this RECAM, which has several factors to determine whether or not it's possible, probable, potential, unlikely. And then during his deposition, I asked him about this, and he admits that his terminology, these probable likelies, and I'm gonna show it to you on the screen in a second, Your Honor, does not relate to medical legal probability standards. For example, it doesn't say more likely than not. It doesn't say 51%. It doesn't say to a reasonable degree of medical probability. Those terms aren't used. And so I had the pleasure of deposing Dr. Alsina for several hours. And it became clear during that deposition just how subjective and unreliable this approach at determining causation is based upon the RUCAM. And that's all he used. And so, Your Honor, by the way, the RECAM, which is it's supposed to be an improved version of this, is called the Revised Electronic Causality Assessment Method. And there's certain automatic warnings for data that's a part of the RECAM that's not a part of the RUCAM. But most important, Dr. Alsina, getting back to Williams, did not consider hydrazine. As I said before, he inputted real water instead of hydrazine as a potential cause, and his analysis followed from there. So, Your Honor, in terms of case law, we believe that Morsicato would prevent an algorithm from being the basis of a causation determination.
Well, an algorithm cannot exercise medical judgment. And that's the specific language set forth in Morsicato.
Exactly, Your Honor. And that's why I started with Morsicato, Your Honor. And I think that's Randall Jones's case, I believe.
It is. That was in front of Judge Earl.
That's right. And then we also cited in our brief, Your Honor, the Williams versus the 8th Judicial Court. You know that case very well, which is a 2011 case. And then Hallmark, of course, which is a 2008 case. So if we could, let's go to Dr. Alsina's first report, Shane. This is the one with Etar as the first plaintiff. It's June 30th, 2024. So when we get there.
I mean, ultimately, how can Dr. Alsina rely, assuming I even went to the level where I think maybe this could happen, but if he doesn't put in hydrazine.
Exactly. It starts right there.
I mean, the bottom line is you can put in all of the alkaline waters you want, but that's not the cause. The cause was hydrazine.
That's right. And his position on this, Your Honor, which I think is self-serving. Could you go to page 6, please, this report?
That goes to the whole foundation of the opinion.
That's right. And this is what is really disturbing when you look at his report. He says there's one article, go up a little bit for me, Shane. One article on real water was found. Now, if you go to the footnote, he talks about the Burke article, which Mr. Kemp raised earlier, and I call it the Loma Linda report, but it's the same article. And then he speaks also about the Zhang document here, notes from the field. And Dr. Zhang was from the Southern Nevada Health District and was a part of the CDC, FDA, and Southern Nevada Health District investigation, Your Honor. But there's actually what he's trying to suggest in this report by saying one article on real water. When the article was produced, Your Honor, the test results originally from the hydrazine testing of the concentrate weren't available. The urethans testing of the real water retail bottles, not available. And so he fails to mention hydrazine in his input because he couldn't find anything on hydrazine. Now, what we did, based on, again, science, we brought to the court, and you probably remember this, Dr. Najee, the foremost authority on hydrazine, as a witness, as an expert in this case. And we already had stipulations earlier today, or non-oppositions, that every test of real water had hydrazine in it. So instead of putting in his input a known liver toxin, he hides behind real water or alkaline water. And so if you could, Shane, go to page 8. Now, this is the RUCAM to the bottom, all the way to the bottom. Thanks, Shane. Here we go. RUCAM. This is this causality assessment method. And he said, I used a standard scoring instrument called RUCAM instrument to score the likelihood that the hepatic injury was due to alkaline water. Now, again, not hydrazine, alkaline water. He says the updated version was utilized for the scoring and the results provided in transparent fashion. Now, what I want to bring the court's attention to is this next sentence. Despite objective measurements, there can be variations in the score due to ambiguity on how to assign the scores. Some elements of the scoring cannot be done. Your Honor, there's no way possible you can first root out the subjectivity, but secondly, for us to cross-examine him when he's relying solely on an algorithm that he didn't create, which he admits leads to ambiguity, for making scoring difficult. So now let's apply this algorithm to each of the plaintiffs. If you could go to the next page, page 10. So he has a section, Your Honor, on every plaintiff, and he talks about what he's reviewed. And then he has a scoring, just the numbers, not the actual underlying scoring towards the end of each section. So if you could go to page 13, Shane. And I won't go through every one of them, Your Honor, but you'll see real soon why this doesn't pass Hallmark. So he indicates here, time of onset, Your Honor, he gave 2 points to. That's the most you can get for that section. And all it means is it fits within the CDC's definition of a probable case. That's what the points are being given for. And then these are the other factors for the under RUCAM. And he comes up with this total score of 3 to 5, which means it's possible, based upon the RUCAM, that this plaintiff's injuries, this patient's injuries, were caused by real water consumption. Now, he doesn't say what else could have potentially caused it. He just says it's possible. I don't know how this could ever assist a trier of fact whatsoever, because it's not given to any.
Well, I mean, ultimately, whatever opinions he has should be his opinions based upon his review of the medical records and all the evidence available, and not running it through a computer program.
That's right. And that's what he did. He relies.
I mean, you know what this reminds me of? It's been a long time. It reminds me of that Crash or whatever program they have in motor vehicle accident cases. And they use this program regarding whether somebody suffered an injury or whatever.
Right.
And I sit down and I say to myself, well, you better bring in a code writer if you want to have that admitted at trial, right?
That's right. And no judge is allowing it anymore. That's
No,
gone. It's gone.
And
It's
it should have
gone. You
been-
don't even see it anymore.
Yeah, I don't even see it anymore. I
That's
remember
right.
that.
Yep. We had that. That was years ago. I'm surprised you remember that, Judge.
I've been around.
And so then he goes to his opinions. Let's go to page 14. And this is why I'm highlighting these 2 paragraphs, first 2 paragraphs of his opinions, because it doesn't pass Hallmark whatsoever. It says, Mr. Eton met the CDC criteria of probable cause of hepatitis. Now, it went for probable. That's what the CDC said because of the definition. It fits his injury, time of injury and onset, fit the CDC definition. This is strictly a CDC definition, what he said. The CDC has not performed a liver injury causality assessment on this case. Now, he hides behind that, but the CDC wasn't charged with that.
They were charged with performing a epidemiological study.
Bingo. That's exactly right. And then he says the CDC never tested Mr. Heatog's real water samples or detected any contaminants. The CDC didn't check anyone's water. They checked the concentrate and found hydrazine in every one. So he uses that as a way of escaping what would be a probable or more likely injury caused by consumption of real water. Then he finally says, paragraph 2, from the liver injury causation standpoint, utilizing a liver causality assessment method, it is possible that real water caused the liver injury. What does that mean in terms of the reasonable degree of medical probability? How does that assist any trier of fact? It doesn't.
I don't know what it means.
It does not mean anything.
This kind of reminds me of what was the theory, alternative causation theory they purported last time?
Oh, that's when UNFW was turmeric.
Yes, and what was the term of art? That was the study from somebody from USC. Idiosyncratic, yes.
That's right.
Thank you, Mr. Pepperman.
Yeah.
That's what it was, idiosyncratic. And I said, what is that?
That's right. And when we were dealing with that issue, I can't remember who did it, maybe Mr. Kemp's office or someone. We had all of this literature that talked about the benefits of turmeric.
Right.
From the early days in Chinese history using turmeric.
And it's my recollection, whoever the expert was, they were well qualified.
Yeah.
So it wasn't a qualifications issue.
Right.
It was an assistance requirement issue.
That's right.
Under Hallmark and it's idiosyncratic. I said, what is this? Where did that come from?
That's right. And so this is the approach, and this is the type of language that does not assist the trier of fact that he uses for virtually every person, every plaintiff that he addresses.
So I want to make sure I understand. When I look at opinion number 2,
Yes.
quote, from the liver injury causation standpoint, comma, utilizing a liver causality assessment method. Is that the method he used to give his opinions? Is that the basis for his opinions in this thing?
He's using, that's the RUCAM, I believe, Your Honor.
Okay.
Because the RUCAM is an assessment method. That's the last 2 letters stand for assessment method. It is possible that real water causes liver injury. So I don't know if he's simply saying, my opinion is it's possible. He doesn't say to a reasonable degree of medical probability. He doesn't tell me if possible is above 51%. He doesn't tell us anything. Nor does he tell us what other issues to a reasonable degree of medical probability could have caused the injury.
And more specifically, utilizing, even if this was reliable, utilizing a liver causality assessment method, we would have to have that based upon the exposure,
That's right.
right? I mean, it wasn't drinking alkaline water, it was exposure
That's
to
right.
rocket fuel.
The factor for every one of these that had to be inputted, which was not, was hydrazine.
Yeah.
It wasn't. The next plaintiff is Hunter Brown. Page 15 is where it starts, Your Honor. And then if we go to the scoring for Hunter Brown, it starts at page 17. And Hunter Brown, not to belabor this, ends up with a 6, meaning not only is it possible, but he's more probable. It's probable that his acute liver injury was caused by real water, consumption of real water. This is without even putting in hydrazine. That is probable. Again, I could simply accept the benefits of this, but it wouldn't be right. Because I don't know what probable means in this context. Is it 50.1? Is it 51? Is it 49? Is it 48? I don't know.
Maybe possible is 51, we don't know.
We have no idea. And he admits during his deposition that it has no relationship to the legal medical opinion in terms of more likely than not to a reasonable degree of medical probability. He says these are terms, probable, unlikely, possible, that came from RUCAM. Which means, how do we know that it has any relationship to giving opinions in a court case? If we go now to Miss Moreno, I believe is the next. And Miss Moreno, this is on page, starts on page 23, I believe. There we go. Carlo Moreno, Your Honor. Now, he indicated in part of his report. Hold on one second. Your Honor, let me make sure we're on the same page. I'm sorry. Go to page 24. I want to show the judge first. Okay, here we go. I'm sorry, go to page 22, Shane. So, Your Honor, in terms of Mr. Hunter Brown, who's a probable, he has similar opinions. But he also speaks to whether or not Hunter Brown could have gotten some form of hepatitis through his use of marijuana or other forms of cannabis. This is on page 24, paragraph 6. And he admits per liver tox, which is a document that tells you what items, supplements, medicines could be a liver toxin, says marijuana and cannabinoids are unlikely to cause hepatitis. So he rules out any other cause.
And when he says liver tox, is that based upon the toxology report as it pertains to?
That you may remember this. There was a list that the CDC had that the Southern Nevada Health District always also printed out in their investigation that had known liver toxins.
Right.
There's a article or a software program you can use to find out what items, supplements are toxic to the liver. So this is what he was referring to. And from his review of the medical records involving Mr. Brown, he found that these items, marijuana, was not a likely cause of his hepatitis. So now you're left with saying he's a probable liver injury based on consumption of real water, and there are no other possible or probable causes. Again, he's doing this based on RUCAM. So it's impossible to be, I would say, this opinion to assist a jury when they cannot cross or examine the RUCAM. He's telling them what, in this case, what Mr. Brown took that may be a likely cause, but determining that it's not a likely cause. And then he says that real water is a probable cause. It's all over the place. I think it's helpful to Mr. Brown in this case, but I can't speak out of both sides of my mouth. I think it's unreliable. His opinions are completely unreliable. They've not been tested. They're untestable.
That's what I was thinking when you were saying that.
It's impossible, Your Honor. So I can't talk out of both sides of my mouth. I can't say I want to take this because it's beneficial to Mr. Hunter, but it's, this is definitely not science here. And I know Mr. Odou said, medicine is an art, not a science. Well, this isn't very artful either. And so, Your Honor, I don't think you can rely on any of his opinions, and certainly it's not appropriate for a jury to try to figure this out. Now we can go to Ms. Moreno. She starts at page 25, and his scoring on page 27 makes her a probable as well. Go to the top of 27. Bingo. Thank you, Shane. So now she's also a probable. Again, I could accept the benefits of this probable determination, but I don't know if it means more than 51%. I don't know if it means 80% or 90%. What I do know is it does not satisfy a hallmark. And if you go to his opinions, go further on page 27, please. This is what he says that kills his opinion, John, in terms of input. Paragraph 1. He says, Mrs. Moreno met the CDC criteria for non-infectious hepatitis as a probable cause of liver illness associated with real water consumption. That would be great for the plaintiff. Then he says, because the causative agent had not been identified, this is not a confirmed case per CDC criteria. Well, at that time, hydrazine again had not been determined because the test results hadn't come back yet. We know that what the causative agent is. And he's yet, knowing the benefits of 10 tests, all 10 positive, he still didn't include hydrazine in his testing for purposes of the RUCAM analysis. And then he says, paragraph 2, from the liver injury causation standpoint, utilizing a liver causality assessment method, the final score is probable that real water caused the liver injury. Again, Your Honor, we cannot be hypocrites here. We can't say we want it for all the probables and possibles and don't want it for the unlikelies. None of his opinions can withstand the requirements of Hallmark. None of his opinions withstand the requirements of Williams. He does not say to a reasonable degree of medical probability what caused these injuries, other than potentially real water. And again, when it comes to real water, he says alkaline water quite often, or real water, but never says or inputs hydrazine. And Your Honor, I can go through each one of these and point these problems out, or I can allow Mr. Odou or whomever will argue this on behalf of real water to address it. And then I can finish on rebuttal. One thing I do want to point out, but I think you may have already handled this because Mr. Kemp brought this up earlier. When it came to Tequante Henry, there was no RUCAM score done because he said it would be difficult to score. I want you to see this. Pull it. What happens when you have 15 lines, 14 of which were reviewed by Mr. Dr. Alcina. Can you put Henry up for me? Henry report for Dr. Alcina? Yep. Okay, perfect. And Your Honor, let's go to the scoring. Okay, your back go up a little bit. Because I think you start past the score. What's Henry on? What's the date number? 51? 51. Yeah, I got it. Thank you. All right. So Your Honor, looking at Henry, the opinions on page start on page 56, I believe. Yep. That's right. So the first opinion deals with the alcohol use, which we've already dealt with earlier in this earlier this morning, Your Honor. And then he recognizes he had liver disease with cirrhosis. Talks about jaundice and for months and drank alcohol. That's all opinions 1 through 5. And then we get to opinions 7 and 8. And he says, in my opinion, it cannot be proven that real water was an independent, direct factor in his decline. So he can't say one way or the other. Then he says a causation analysis must rule out alternative causes. His root cam score was -3 excluded, which we never see it. He just tells us that. Then he says an alternative cause,
And it didn't even indicate that it was hydrazine.
didn't even do it. Then he says an alternative cause, alcohol, was highly probable. Again, we don't understand that because we don't know what the highly probable means or even probable means. And it says root cam in a patient with cirrhosis who undergoes treatment for alcoholic hepatitis, who undergoes a transplant, is highly difficult to score. That's his last comment. And so when Mr. Kemp was going through this with you earlier today, he alluded to the Keck medicine, Keck School of Medicine at USC. Have you had approach on?
Yes.
And one of the things I wanted to point out is Mr. Odou said during his argument that this was just one reference in a medical record. There was not even a committee to discuss the pathology, which is the biopsy. And I said, you know something, we make sure that the court realizes the significance of this document. This is the liver core biopsy dealing with Mr. DeQuante Henry. The collected date is June 18, 2021. And under the comments section, under findings, it says findings are most likely related to acute liver injury related to real water. Preliminary findings conveyed to Dr. Kim on 6/22/21 and case discussed in liver conference. This is multiple doctors discussing the biopsy, Your Honor, and coming to this determination. This is what I find to be extremely problematic for Dr. Alsina because he doesn't consider this finding. And in fact, I presented this to him during his deposition. The root cam obviously did not include an input of hydrazine. Your Honor, there is no explanation that can be offered why a known liver toxin was not utilized in every root cam analysis, if you're going to even give that any credibility, which I would believe it does not deserve any credibility, which we can examine. He's not the author of it. He didn't use the RECAM, which is the newest version of that. And he's not providing any of these opinions to a reasonable degree of medical probability, Your Honor. There's no way for us, or anyone, I would say, to properly cross-examine an algorithm. I don't believe the algorithm satisfies Hallmark, and I don't believe his opinion is consistent with Williams. And with that, Your Honor, I will save any time I need for rebuttal, but I will tell you in every one of these, and I don't want to just put in front of you all of the probables, because there's several more probables. There are a couple of unlikelies. And there's somewhere he just says there's no cause identified. But we're not trying to take the good and leave the bad. We think that all of it should be excluded, John.
Thank you.
Thanks.
Okay, let's hear the opposition.
Thank you. One second, let me get my pages correct here. Well, this is interesting. I think I'll start with the Keck School of Medicine. My father was a USC medical graduate, and he was always annoyed that they named it the Keck School of Medicine. He thought it shouldn't be named after one person. That was a little bit of a stretch for the university, but unfortunately,
You got to worry about donors, right?
apparently so. He always thought it should be the USC School of Medicine, and they've made a lot of money naming schools after people, but it always looks odd to me as well. Anyways, he graduated in 1949. Your Honor, I think the interesting thing about the medical record from USC is the date. This is before the FDA tested for hydrazine. So the fact that they're reporting that real water caused this injury came from Mr. Henry. By this time, real water had been in the news. I don't blame Mr. Henry. He was gone through a traumatic liver transplant. He was very sick. I am certain they were upset that he was sick, didn't know what the cause was, saw real water and assumed it must be real water. And now it has turned out to be true that it was real water. But to say that that the proof is, the USC said that he was injured by real water because he said so, doesn't meet any medical tests. It's simply a notation in the medical record, no different than his alcoholism. So again, I stand by my earlier comments that patients are going to show up in an emergency room or an emergency situation. They're going to say what they think made them sick, and the facility is going to dutifully record that. I'm sorry, Teddy.
No, you're good. I just moved these things. Sorry about that.
No worries. So I don't think that this USC medical record is anything other than what it is, which is the patient reporting at that time what he thinks made him sick. Certainly USC didn't have the FDA testing of hydrazine. Certainly USC didn't have the later testing done by UNFI testing the retail water and finding hydrazine. So there's got to be some basis in fact for the conclusion that in this date, in June of 2021, that hydrazine was the cause, and we don't have it. So you say, aha, that's the case. That's not true.
What
Second,
about the histological testing?
the histological testing that USC did,
Yeah,
it's histological testing. They're testing for a toxin. They're trying to figure out what is going on with their patient. Those are objective tests. I have no problem with that. My problem is just with the conclusion, because they have no way to link real water to hydrazine at this point. Just like our doctor, Dr. Alcina, used real water rather than hydrazine as his input for a tool. RUCAM is a tool. Doesn't take the place of the doctor's opinion to a reasonable degree of medical probability. Dr. Alcina has 25 years of experience doing liver transplants, just like the type Mr. Henry got. He's well qualified to render opinions on liver transplants. He's well qualified to render opinions on the care of patients with liver transplants. I don't hear plaintiffs attacking that, but I've heard some broad brush strokes about all his opinions are now somehow magically unreliable because he used a very common tool that practitioners use to try and figure out what's going on with the patient. And that's really all it is. RUCAM is just a tool. It's not substitute for a medical opinion to a reasonable degree of medical probability. It's certainly not a legal opinion. It's just a tool. And if this court were to exclude Dr. Alcina's opinions in using this tool to arrive at those conclusions, that's one thing. But I think to try to exclude all of his opinions goes too far, and it certainly isn't what the plaintiffs asked for in their motion. Dr. Alcina has numerous opinions about the care of these people going forward, their current condition. All of those are to a reasonable degree of medical probability. In fact, all his opinions are to a reasonable degree of medical probability. And looking at, I have to switch glasses, and looking at the plaintiffs in this case, there were a number of plaintiffs that he conceded it was probable that that real water, just like USC said, caused their injury. Obviously, it's hydrazine in real water that caused their injury. Let me go and pull up a specific one that Mr. Parker didn't talk about. Not because it has anything different, because I think it's important to see all of Dr. Alcina's opinions. Oops. And I think if the court looks at these opinions, you'll see that there are multiple opinions here. Trop, could we go to page 2, to the PDF page 246 of our opposition? Do you have that to plaintiff's motion eliminating number 10 to strike Dr. Alcina?
246.
Yeah, page 246 of the PDF. There we go. Thank you. As we'll see, this is for plaintiff Mr. Munoz. He developed liver failure within 1 month of drinking real water in 2018. He was transferred to UCLA for a liver transplant. Kind of funny when you see USC and UCLA together in a case. He didn't know the reason that he was sick. We're not trying to hold that against him. We're not trying to say, just like plaintiffs, aha, here, there's no reason given in the medical record, therefore it's not real water. The court's already found that real water is liable for putting a product into the stream of commerce that was dangerously defective. He didn't meet the CDC definition. These are just observations of Dr. Alsina. He's giving an opinion about various observations and various findings of the CDC. He's reciting facts of the case. He's not saying that he disagrees with those facts. He even looked at marijuana use for this particular plaintiff and noted that it can be hepatotoxic in large enough doses. But again, he gets probable, and he's even conceding, and this goes to the Williams analysis, he's conceding that real water caused this liver injury. That doesn't negate his opinions about all of the other care and the fact that Mr. Munoz was not septic when hospitalized, or his future care. So if we look at all of his opinions in totality, we'll see he's rendering medical opinions to a reasonable degree of medical probability regarding the care of these plaintiffs going forward. He's got future care opinions on all the plaintiffs, and the fact that he used RUCAM as a scoring tool, just like he would in his practice, is really the key here. He's treating these plaintiffs as he would treat a person who is coming into his office for treatment. He's doing a RUCAM analysis just like he would. So even if the court were to exclude the RUCAM analysis, all of his other opinions should still come in, because he is providing opinions pursuant to his 25 years experience being a Harvard-educated hepatologist. So, Your Honor, we would submit that plaintiff's motion is too broad, and that, and finally, the plaintiffs say, well, we can't cross-examine his RUCAM score. Well, they just spent 45 minutes arguing how they cross-examine the RUCAM score in front of Your Honor. And they certainly spent 2 hours cross-examining Dr. Alsina as to how to make a RUCAM score. We've attached literature showing it's generally accepted by practitioners to use this tool. And that's all it is. It's just a tool. So if the court's inclined to strike the causation opinions, we believe the court should not strike his medical opinions as to care and treatment and future prognosis of the plaintiffs, which is set forth in rather painful detail in his reports that are quite lengthy. Thank you, Your Honor.
Thank you, sir.
Your Honor, it did take a few hours to depose Dr. Alsina, because we had to go through each one of his opinions on each one of the 14 plaintiffs that he evaluated. And that's why it took so long. But the reason why we're here is because a trier of fact, a jury, should not be provided with opinions that are not allowable under Hallmark. And the court said earlier, and it's true, our Supreme Court did not accept Dauber, but the court was very plain that the district courts are the gatekeepers. And to allow,
I think that was very important at the time, because it was a general consensus of the district court bench. It's my recollection as a practitioner. They said, just let it in, let the jury decide.
that's right.
There was a lot of that going on.
That's exactly right. And quite often, lawyers, and I'm not saying this about Mr. Odou, but lawyers will run into the court and say, it goes to weight, not admissibility. Well, you first got to get past these tests. And it took 2 hours to get to the heart of things so that Dr. Alsina could finally admit that without the RUCAM, he has no opinions. every opinion that he has in terms of these patients, he did based upon a RUCAM scoring, except the one he didn't do for Mr. Henry. I think there's one other one where he said because it was not an acute liver failure in his opinion, it was more gastro symptomology. But with those two exceptions, everyone else, his opinions were tied to RUCAM. And that's it. And then what I thought was a mistake in terms of what Real Water's counsel just said, what Mr. Odou just said, the CAC report that was generated after a liver conference, that conference didn't include Mr. Henry giving his opinion of what caused his problem. So when Mr. Odou said, oh, that's just taken from some comments made by Mr. Henry wasn't sitting there among those doctors saying, you know, I didn't go to medical school, but I did stay at a Holiday Inn Express last night, and this is what I think caused my injuries. That's not what happened. They had the biopsy. Doctors reviewed that biopsy and made this determination. Now, it's true that the test results hadn't come in yet, but they ruled out everything else. They were familiar with the alcohol use and found that it wasn't alcohol. Again, supporting what the court has already done. Your Honor, there is no saving Dr. Alcina. One thing I also wanted to point out to the court is in Real Water's opposition papers, page 7, it says here, can you put that on? Lines 12 through 14 says here, the fact that Dr. Alcina used alkaline water admits that they didn't put hydrazine, and the RUCAM analysis does not go through admissibility. Your Honor, that's exactly where it goes to. He did not use and did not place in his RUCAM algorithm the fact that a known liver toxin was consumed by these patients. He didn't put it in there, skewing the entire process. The Williams decision, Your Honor, says the defendant's expert does not, if the defendant's expert does not consider plaintiff's theory of causation at all, which is hydrazine, then the defendant's expert must state an independent alternative cause to a reasonable degree of medical probability, because he or she then bears the burden of establishing the causation fact for the trier of fact. That is completely missing in Dr. Alcina's reports. Completely missing. He does not give anything to a reasonable degree of medical certainty or probability in terms of alternative causes, and he never included hydrazine. And that's the admission. He admitted in his deposition, and it placed Real Water in a position of having to concede that in its briefing, Your Honor. And then if you look at Dr. Alcina also testified to the fact that he couldn't find any hydrazine literature. And for that reason, he couldn't use it. Your Honor, again, CDC used the list. It's in the CDC records of hydrazine being a known liver toxin. This isn't new. He just chose not to use it because he knew then, in all likelihood, his scoring would be more probable in favor of the acute liver injuries being caused by Real Water. And then, Your Honor, I also want to point out page 3 of our reply brief, if you could put that up, James. And these are problems that the National Institute of Health, all the way at the bottom, lines 20 through 28. Says here, further, National Institutes of Health articles cited to and attached in support of the opposition confirms rather than dispels the inadequacies of Dr. Alcina's RUCAM opinions. And that it goes on to say that since 1993, there have been 3 major problems with RUCAM. Unclear operating instructions and subjectivity, which is what I started with earlier today, leading to poor reliability and usability. Unclear validity due to lack of accepted gold standard and domain criteria that are not evidence-based. A significant, next sentence says, even the updated RUCAM, which is quite similar to the original, retains a significant degree of subjectivity in terms of ruling out competing diagnoses. And then I'm gonna skip all the way to the end, Your Honor. It says, however, establishing a causal relationship between exposure to an agent and the appearance of liver injury remains the Achilles heel in DILI research. And improved standardization, automation, and reproducibility and causality assessment are needed. Your Honor, there is no way this algorithm and the opinions based on this algorithm meets the hallmark test. And it doesn't meet the Williams test, Your Honor. And for that reason, I believe that all of his opinions based upon all of his opinions on these four patients should be excluded, Your Honor.
And I just want to make sure I'm clear, other than the RUCAM based opinions, which ultimately come to the conclusions that we've been coming to, are there any other opinions he has outside of that?
Well, I will give you an example. There is an opinion in terms of Mr. Henry and his shortened lifespan. Can you go back to Henry?
Yeah, because I want to make sure I'm clear on that, because
That's a good point, Sean.
the way I look at it, I'll just deal specifically with the RUCAM. First and foremost, and I do feel that this is an important issue when it comes to relying upon any sort of software-based tool other than an X-ray or a CT scan or an MRI or things that are commonly relied upon. You look at this process and we don't really know what the process is as far as how it's used. And what I mean by that is what goes into it, who wrote the software, what does the software consider? Because ultimately, it's not the data that's inputted, it's the basis for the ultimate conclusions, and we don't know that. Just as important too, I would think at a minimum, even if it was reliable, you'd have to put in the correct toxin, and that would be hydrogen.
That's right.
You know, and it doesn't go to the weight. We don't have the appropriate foundation laid for RUCAM analysis. Maybe that's what I'll call it, or RUCAM conclusions.
I agree.
I don't see how it meets the assistance requirement as set forth in Hallmark. And I do understand the requirements as far as independent alternative causation theory is set forth in the Williams case. And those opinions have to be to a reasonable degree of medical probability. More likely true than not. I get that.
So let me show it to you, Your Honor, the one that I was speaking of. And I'm assuming that Mr. Odou was also using that as an example. Am I right or wrong on that, Joel?
Using
Henry and the other opinions that he may have that
the motion
Dr.
didn't make any reference to Henry, so we didn't address it.
I mean, I'll bottom line it before we get it. Any opinions of the doctor based upon RUCAM shall be excluded.
So let me give you an example why I think this also addresses what Mr. Odou said, even if he wasn't specifically referring to Mr. Henry. If you go to page 57, oh, you got it up, thanks. It says here, although his life expectancy may be shortened with a liver transplant compared to the normal population, Mr. Henry had a chronic liver disease, for which a transplant could have been needed anyway. Well, again, he's comparing an alkaline water to an alcohol issue for which he has no opinion to a reasonable degree of medical probability. And he does not consider, which goes back to Williams, how hydrazine can permanently scar the liver. And so now we all agree that he has a shortened life expectancy, but because hydrazine, a known liver toxin, is more damaging than alcohol, it takes even a shorter period of time. We have the Loma Linda report that says within 2 weeks, you can have permanent damage. He can't say to a reasonable degree of medical probability and should not be allowed to offer an opinion that Mr. Henry's life expectancy is simply shortened as it would be for alcoholism. That's what I'm trying to prevent, what he should not be able to do. He should not be able to compare anyone between damage done by alcohol versus hydrazine. Now, in terms of Henry, which
I mean, the bottom line is he never considered hydrazine, did
he
he?
never did. So be it Mr. Henry, now Mr. Henry's liver was taken out, so he's dealing with a new liver. But we've also learned through these cases that rejection drugs are an issue. Various forms of cancer are an issue for those who've had liver transplants. And he's never considered any relationship to the shortened lifespan or any other possible issues arising from the consumption of hydrazine. And so even his last opinion, opinion number 8, says here, his opinions are based upon the RUCAM. RUCAM was not performed, but he still refers to it. So I don't know what opinions he actually has that are not RUCAM based or that actually considered hydrazine. I believe that none of his opinions considered the consumption of hydrazine. And he said,
Well, I mean, if you read opinion number 8, it says, in my opinion, it cannot be proven that real water was an independent direct factor in his decline. Well, at that point, real water was a alkaline water, right?
Right.
But he would have to factor in hydrazine.
which he didn't do. That's right. And so every opinion that I've reviewed in his 2 reports, which considers 14 of the 15 plaintiffs, they're RUCAM based determinations, or he mentions RUCAM in his opinions, which he says he can't, that can't either rule in or rule out their either their current condition, their causality, or where they're going in the future. Because he said there's only one article on hydrazine, and as a result, he couldn't consider hydrazine, and he didn't use hydrazine. So I can't think of an opinion that he's offered that does not have some relationship to RUCAM or the fact that he did not include, as required by Williams, the plaintiff's theory, which would be the consumption of hydrazine, Your Honor.
Do we even know whether and I don't know if this is an obvious question, do we even know whether the RUCAM program even has a hydrazine input?
We don't know. I don't know, Your Honor.
And the only reason I asked that, maybe that's why it wasn't included. Because remember, there wasn't a lot of research as far as hydrazine was concerned, and we had the world's most renowned expert testify to trial as to hydrazine.
That's right. And the thing is, you would think, at least I thought he would have done this, but when I spent as much time as I did in his deposition, if you're going to try to be, objective and fair to both sides, at least put in a known liver toxin. You don't put in a benign item like alkaline water, believing that's going to give you a fair result. It's like that old saying, garbage in, garbage out. You have to put in at least a known liver toxin, which he didn't do. He put in alkaline water, which is why I showed the court page 7 of the Real Water's opposition.
I mean, really, unless I'm missing something, alkaline water just in and of itself is not a known toxin. It's hydrazine.
That's exactly right, John. And for that reason, I don't believe there's any opinions that he can offer that are not either deficient under Williams or deficient under Hallmark, John.
Your Honor, then they should have brought a more clear motion. He filed a rebuttal report on the life care plan of Henry. That has not even been raised today. There are opinions independent of RUCAM, and now plaintiff is asking for a greater relief than they sought in their motion. And we think, we understand the court's ruling on RUCAM and RUCAM related opinions, but to now try to expand it beyond that without full hearing of the issues, without us having an opportunity to respond is improper.
Mr. Parker, what about that? Because I'm looking at through this lens, I'll be clear for everyone. These RUCAM-based opinions are out.
Understand that, Your Honor.
But I understand your issue. I do. That's why I'm just making sure the record's real clear. For example, hypothetically, I mean, apparently he's a really well-qualified doctor. He relied on RUCAM. just like the other doctors are really well qualified, what do they rely upon their methodology?
Something, 8 of all of the experts that have been identified in this area, and we put this in our reply brief, he was the only one who used RUCAM. None of the other hepatologists used it. So he stepped out on a limb, to Real Water's detriment.
But I'm just being real clear on this, and here's my point. Mr. Peppermint, what was the,
Idiosyncratic.
yes, and they gave their opinions based upon this idiosyncratic method in the other case, Gallagher case, and they were really well qualified, but I didn't accept the idiosyncratic method or whatever it is. And here's my point. I'll be very cautious as far as my decision. And if there's other potential opinions you want offered that aren't based upon RUCAM regarding life care plans or other issues or future treatment and those types of things, I'm not going to have a sweeping
Thank you.
decision on that. I'm going to the RUCAM and independent alternative causation theory.
Thank you.
Yeah, I think I cleared that up, didn't I?
You did, Your Honor. So it's my understanding, any opinions based upon RUCAM are not.
As it relates to independent
causation,
theory,
right,
plausibility, causation theory,
all gone.
any of that.
And if he has an opinion that's outside of that,
Oh, yeah.
not based on RUCAM, then you can address that at the time.
Exactly.
Makes
I
sense.
just want to make
Thank you
sure
so
I'm
much.
not too overbroad.
Thank you, Your Honor.
So granted regarding RUCAM as it relates to independent causation theory and plausible.
The independent alternative causation theory. I don't think he offered up a plausibility theory. Yes. You know what I'm gonna do right now? I'm gonna step down for about 5-10 minutes. I have to read an order. So it gets published today. Something I worked on this weekend, so I wanted to make sure it gets published. It's like dealing with like 5 motions. And as soon as I'm done, I'll come back on the bench. I just want to take a look.